So as people are coming in, just to introduce, so we have Nick. Sorry, I'm pointing this way, but we have Nick, who is our technical host. So he'll be doing all the stuff in the back end, kicking out people we don't like and letting people we like come in. And then we've got Juliet and myself. We're going to be co-hosting this event. I'm taking the place of Pastor Greg, because initially Pastor Greg and Chee were the one who are organizing this, and they're on annual leave, so I'm kind of stepping in the meantime. And then we've got Peter as well, who's the key person you've all come here to listen to. Welcome, everyone. For those who are not part of our church community, welcome. My name is Chee. I'm the senior pastor of Christ. And kind of hosting events, two ministries in our church. One is called Embrace, which is our women's ministry, which Juliet oversees. And then the other is Empower, which Frank oversees, but we do have a team around that, which is Ash, Joe, Adrian, and Nick. So just really quickly, while we're kind of still waiting for people to come in as well, I just thought it'd be nice for them to just share a little bit, really quickly, what Embrace and Empower is about. So Nick, maybe you can start.
Oh, I was going to say ladies first. But hi, everyone. I'm Nick, helping out with the team. So I can see Ash is also here, and Joe, Frank, and Adrian. We've started to reconnect with people during this time of COVID, and so we're just there to support men in our church, but men also outside of the church community, because it's during this time of isolation, stage 4 here, when we can really go the extra mile just to connect and to build relationships. So Empower's here for you as men, to look out for you, to make sure you're not alone. And like these events, combining with Embrace, we're just looking to journey with you and to make sure that there's anything we can do to help with prayer and even with your needs, that we're there for you. And yeah, so we're praying for Pastor Greg, and we're also looking forward to seeing him back after his annual leave.
Great. Well, thank you, Nick. What about you, Juliet? You want to share really quickly?
Yeah, sure. So the Embrace team is myself, Yin, Lauren, Chee, and Jen, and I've forgotten somebody.
It's okay. I'm sure
Maybe.
they'll forgive you.
Off the top of my I'm sure there's somebody else. Oh dear. Anyway, so our women's ministry has been running for a while, and during COVID, we've been brainstorming different types of events that we can provide a platform for the women to connect over. We've been doing lots of exercise together, had a few Zoom events, and this one with Peter today is something that Chee thought of, because she has a personal connection with Peter via her sister. And during the first lockdown, she sort of thought, this might be something that would be good during this current climate for people to be aware of and informed about. So it was a great opportunity to combine with Empower to give access to the whole church family, not just the women, to learn about this kind of thing. So it's good to see, as Pastor Chee said, a whole range of people from very young to more mature. So I think it's going to be very useful. So, and if there's other events that you would like to do as far as the women go, please don't hesitate to email us at embrace@claytonchurch.org.au, and we can look into it, see what we can do while we're still in lockdown.
Great. Fantastic. Well, just give you a bit of an outline today. So basically, I'm going to introduce Peter in a second. So he'll kind of chat with us for about 25 minutes. In the meantime, as he's talking about will preparation, if you have any questions, if we can channel our questions through the chat function. So if you go to the very bottom, there's a tab that it says chat, and then just type your questions in. And then what we'll do at the end, after his talk, for the remainder, like 30 minutes or so, we'll actually go through as many questions as we possibly can, okay? Now, at the end of it, what we'll also do is just share a little bit about, we believe as a church in Jesus and how he transforms people. And he impacts everyday life and everyday people. And so what difference does Jesus make in the area of will and planning and estate planning? I think we're going to, kind of maybe discuss a little bit at the end. And then basically there's a survey that most of you would have gotten in your inbox now. It's just going to take only about 3 minutes to be able to fill out, but it's a bit of a feedback survey for us. So after this event, if you could actually go and fill that out, that would be super duper helpful. So without further ado, let me introduce Peter Ng. He's actually used to go to Clayton Church. Is that correct?
Yes.
Yes.
In the 80s.
In the 80s. I was born in 1999. So he used to be a Clayton Church boy. So Peter's an Australian legal practitioner. He graduated from Monash University, currently practicing law as the principal solicitor of a boutique legal firm in Melbourne called Cornerstone Lawyers. Now, prior to entering legal practice, he has an associate director of a private equity investment company, specializing in managing and raising the public profiles of small and emerging companies in the mining and renewable energy sectors. He also has experiences in managing portfolio investment funds, covering listed equities, fixed income securities, and real estate investments. He has a Bachelor of Economics, MBA, a Master's of Law, a graduate diploma in legal practice, just to name a few. He currently sits on the board of 2 companies that is listed on the ASX as its independent non-executive director. Peter worships City Life Church and serves in the music and life group ministries. He's also involved with Bible study fellowship. So in all that list of accomplishments, I think his biggest accomplishments, he's got 3 children, 2 daughters, 1 son, and he has only 1 wife. So fantastic. So why don't we hand it over to you, Peter? And yeah, go for it.
All right. Thank you, Pastor Chee. Good afternoon, everyone. Great to have all of you here. Indeed, I was in Clayton Church in the 80s, and I see Robert and Carol. I see Winston, Anna George, just to name a few. These are people that I've sort of seen on the screen, people who hopefully will remember me from back then. But look, really great to be here sharing with you. Now, good afternoon, and as introduced by Pastor Chee, my name is Peter. Terribly honored and humbled to be invited. Just to share a little bit about the matter of last will and testament. Oh, by the way, I've also seen Tutin as one of the attendees today. Many thanks to Pastor Greg and cont who initiated this, and also Pastor Chee, and Nick and Juliet to facilitate. There are a number of you that I know. So hello, a number of you that I don't, greetings to you. Disclaimer, this is my get out of jail free card. So read it however you want. But more importantly, I want you to know that this is not a business solicitation opportunity. I'm not signing you up for MLM. I'm not saying that you have to come to Cornerstone Lawyers, rather a sharing of knowledge and experience from me to you, okay? Let's get that very clear. Now, what is a will? Let me start off by asking you this question. What is a will? And then a follow-up question of why write a will? Well, in a real sense, we follow the example of our God. And if you think about the Lord's Prayer, for example, how does it go? Our Father who art in heaven, hallowed be thy name. What's the next one? Thy will be done. All right, so I'm just cracking a little joke, just making sure you're not falling asleep on the Saturday afternoon. If God would to do his will, what's stopping you from doing yours? Maybe that went a little flat. Pastor Chee might want to speak to me a little bit later. Look, a will is a written document in which you state how you want your property distributed after you die. All right. Of course, there's nothing in the Bible to instruct us to make sure that our will be written. But succession law is very much in place in ancient Israel. If you go back to the Old Testament, how your inheritance is to be given out is very, very clearly stated. Therefore, the principle we can take away from that is that we need to be clear. There are plenty of references to ensure that you put in place clear instructions yourself in the Bible. And if you look at 2 Kings chapter 20, verse 1, the prophet Isaiah told King Hezekiah to put your house in order because you are going to die. Now, if I were to conduct a poll and ask which one of you do not wish to die, I'm sure there will be, the outcome will be very, very obvious. But if there are any certainties in life, it is death and tax. We all will die. And the prophet's exhortation to King Hezekiah to ensure that his matters are put in order. Why? Because when there are no clear instructions, what you will create is unnecessary squabbles, disputes, confusion, and all this will add to the sense of grief during the loss of a loved one. Therefore, it is a good and responsible act to make a will as part of our Christian stewardship. I'll repeat that again. It is a good and responsible act to make a will as part of our Christian stewardship. A will can protect and provide for the care of children, spouses, parents, and bestow gifts to religious organization. And God is interested in what happens after you die to the money and to the property he has entrusted to you. Now, that really is a will. Some people then ask, should I disclose the details of my will? Should I share it with people? It's really up to you. It's your personal choice if you choose to disclose the details of the will or to maintain confidentiality. While we're in the area of estate planning and wills and all that, there's this thing also about a power of attorney. I'll just give you a brief background on that. Now, a power of attorney essentially authorizes another person to act on your behalf, all right? So a power of attorney, in a sense, acts while you're alive. A will comes into play when you're no longer around. So, and there's another difference, which is an enduring power of attorney. And this is an instrument which remains operative regardless of the severity of any disability affecting the donor. So in other words, if you are no longer conscious, you are unconscious, or you may have suffered dementia, enduring power of attorney remains in operation. Now, in general, there are two types, and that's a power of attorney for general and financial, and a medical treatment decision maker. That used to be called medical power of attorney under the old law. Now, under Victorian law, enacted about 2 years ago, a person, including those with dementia, now have the power to refuse medical treatment or resuscitation even after they lose consciousness or forget who they are. And why I'm telling you that this has happened about 2 years ago really is because law changes from time to time. If this is something that you know a while ago, even whether it's about wills or whether it's about a power of attorney, bear in mind this changes from time to time. So it is important, it is in fact imperative that you should also be updated, and that's why in a real sense why lawyers are here for you, and why sometimes an understanding of the general operation of this area is going to be very useful. Yeah, I've covered that. Now, we'll go on to what are the requirements that you need for a will. Firstly, it must be in writing, although not necessarily in English. So if I have clients who come from a country where English is not the first language, they've got it written down in their native language, that's fine, as long as it meets the formalities, okay? So first takeaway, it must be in writing, although not necessarily in English. Now, the second point, if it is executed before 20th July 1998, some of you are not even born yet, the will must therefore be signed or marked or acknowledged by the will maker at the foot of the will. Does it, by implication, mean that if it's signed after, it need not be signed? Well, there's a whole body of law in that area. I'm not going to go into it, but suffice to say, I would highly recommend and say that it's prudent that you sign the will at the foot of the document, okay? Now, another person can actually sign on behalf of the will maker if the will maker is competent and directs the other person to do so. But again, the preference certainly would be for the will maker to sign it personally. One other requirement, the will maker must be above 18 years of age. All right. Moving on. The signature, mark, or acknowledgement of the will maker or testator must be done so in the presence of two witnesses. So if you want to write a will, make sure you have two witnesses to be able to sign off and say that they've seen the will maker do so without a gun being held to the temple or without a knife at the side. All right. is important because it's also to show that the will maker did not do so under duress. So while we are at the matter of witnesses, let's talk about who then should witness a will. It is preferable, okay? So let's differentiate between what's legal and what's preferable. It is preferable that beneficiaries or potential beneficiaries to a will, the spouse of a beneficiary or any relation to them, do not act as witnesses. I'm sure you know why. Very simple, conflict of interest. Yeah. So it is preferable that this class of people do not act as witnesses. So besides needing to establish the witnesses, we also need you to be able to find this category of people called an executor or a trustee. What are they or who are they? The offices of an executor and trustee are quite separate, although it's usual to appoint the same persons to fill both offices. The task of executor, essentially, you will see on the slide, to bury the body, gather the assets, safeguard, pay the debts, and remaining assets handed over to beneficiary. The trustee, though, is to take control of the trust asset and administer them for the benefit of the beneficiaries or objects. For example, if I say that when I die, everything goes to my children, and if I have children under the age of 18, these assets will therefore sit with the trustees first before the children of my beneficiaries reach the age or fulfill those conditions. All right. So these are the executive and trustees, and they are people that you have to have, and we have to write that into the will and appoint them. What else? Some thoughts certainly should be given to who you want to act as executors of a will. For partners, husband and wives, we would usually be the first port of call, and so you could therefore, the next person could always be, say, a close relative or close friend. It is desirable to appoint persons who, number one, have a high standard of integrity, number two, can be trusted to carry out the intentions, are accustomed to acting in a business-like manner, and number four, impartial in the event of any disputes. All right, so think about that as well. Now, beneficiaries. Your first responsibility as a will writer, a will maker, sorry, will be to provide for your family. 1 Timothy chapter 5, verse 8 says, anyone who does not provide for their relatives, and especially for their own household, has denied the faith and is worse than unbelievers. All right, so certainly your beneficiary is to provide for your family. Then you may have the opportunity to consider whether to benefit your church and other organizations. And Galatians 6:10 says, therefore, as we have the opportunity, let us do good to all people, especially to those who belong to the family of believers. Now, this, for example, is, you could always say that when I'm no longer around, I want to give X dollar to the Melbourne School of Theology, to this Bible college, or to World Vision, or to something else. And I'll give you an example. For example, now, many of you might have seen the new RSPCA building along Burwood Highway at Burwood East, the new spanking building. It is said that the funds to build that building actually came from two estates. Both were more elderly people in their 80s and 90s. Both of them passed away without family, and they left their entire estate. So two of them, one apparently about 2 odd million and one about 3 odd million, to RSPCA. And RSPCA, with that funds, was able to build the new center that they had. Historically, we know a lot of people who have also given funds to Bible colleges, to churches, and all that. And certainly this is a place in a will that you could therefore specify, so that an organization or your church could benefit from it. Now, what if you have a beneficiary with a disability? This is when we will encourage the will maker to have it written down and create a testamentary trust. And this is when a trust is created after death, not before, it's after death, right? Or people who beneficiaries who may be mentally incapable or drug or alcohol dependent. And in this instance, the choice of trustee becomes very, very crucial. Appointing a siblings could sometimes cause trouble, but the bottom line is the person who can provide the best care to such a beneficiary. All right, moving on. So that's looking at changing or updating a will. After writing a will, you come to a situation where you say, "Oh, I've changed my mind. That son or that daughter is no longer in my favorite list. I want to change my allocation." Unfortunately, once a will has been signed, there can be no alteration, either by crossing out or writing in new clauses. Okay, alteration such as this will have no effect. Actually, it may even nullify your will. So once the document is signed off, it's completed, it's important that nothing gets done on it. Some of you with avid interest in Chinese history, as I am, will remember the Emperor Yongzheng of the last Qing dynasty. It is said that he wasn't the necessary successor to the throne, but because somebody played a trick on the father's will where they put an extra dot or a slash, and from the 14th prince became the 4th prince, and he ascended the throne. So that's a bit of a history for you, but really there's no changing, there's no updating a will. How does marriage or divorce affect your will? Now, if you have a will right now and you get married or you're divorced, the will is automatically revoked. However, a will that is made in contemplation, that I'm going to get married or I'm going to get divorced, we must have that additional statement written in there. All right. So if you do not wish to have a will written in that way, a new will must be written after you marry or you divorce. Otherwise, you will die intestate. Or intestate simply meaning you die without a will. So having said all that, how do you contest a will? People can contest your will. All right. You do not think that my will is my absolute last word. Your will may be challenged. That firstly, you were not of sound mind. That you were unduly influenced or pressured by another person. That the will did not meet the formal requirements. I'll give you an example that I've come across. Somebody actually bought a post office will kit and thought that, oh, as long as I fill everything up, that will do. He did not get it witnessed. That's one of the formal requirements, if you remember the slide earlier. He passed away. The son brought the will into our office, took a look and said, no, the will doesn't meet the requirements, and therefore my client's father passed away intestate. Okay, so if these are the situation, wills can be challenged. What are the areas? Another factor for challenging a will is that you fail to make adequate provision for the proper maintenance and support of a dependent. So one of the few things we tell people is that when you do a will, it's really 2P. And if you don't remember anything else for this afternoon, just remember this. A will is to provide, number one. And number two, a will is to protect. So to provide, certainly provide for people who are still dependent on you. And to protect is to protect, for example, you may have aged parents staying with you, but who do not need the financial support, but they might need a roof over their head. And this is a real life example. If you remember back about 2.5, 3 years ago, there was this shooting case in Brighton. And at that time, people thought it was a terrorist related event, but no, it was just a person who was mentally unstable, picked up a gun, fired a few bullets. I believe 2 persons died. One of them was the manager of a service apartment, young man in his early 20s, just married about 2 years. No children, no will. So everything went to the wife. But what happened after the wife got hold of the property and whatever money that she had, she turned around to the in-laws, so that the deceased father and mother, and said, I want you guys out of the house. And they said, you can't do that. This house belongs to my son. They said, no question about that. But this house now belongs to me, and I don't want you in the house. The son could have prevented that by writing in the will, I'm giving my parents a life estate. So that's how you can protect. Once that statement is given in the will, it will be a statement that will be placed in the certificate of title, and that will at least protect the older folks. Yeah. So to provide and to protect. Who would be eligible to bring a challenge? Certainly your surviving spouse or de facto, your children, including ex-nuptial, adopted and stepchildren, your parents, your divorced spouse who's receiving or entitled to receive maintenance from you at the date of your death. So it's not just your last word. You need to give mind and consideration to all these people as well. We have already mentioned what happens if you die without making a will. Then essentially you are said to have passed away intestate. And the consequence of not making a will, if a domestic partner, and I use the word domestic partner from a legal perspective, all right, is left by an intestate or person without a will, with no children, then the domestic partner will inherit all. Or any assets held in joint tenancy will pass by virtue of death to the surviving joint proprietor rather than according to the intestacy. The second point really is more relating to property, right? So if you have joint a property in joint names, it will go to the other person rather than in accordance to the will. What are the other consequences of not having a will? First and foremost, if there are no domestic partner or children, then those most closely related by blood to the intestate will inherit. And I've got people who come to me and said, I don't want my money to go to the government. Let me assure you, first and foremost, the government doesn't want your money. Only when absolutely no blood relation exists will the estate pass to the crown or bona potentia. Just have a look at the graph below. I hope you can see it. There might be a lot of details, and I'm not going to go through all of it. I'm just going to very briefly take you through, say, from the top, and that's you. If you pass away, and this is when you pass away without a will. If you have a partner, then that's the row on the column on the left. If you pass away without a will and you have no partner, then the one on the right applies. Just saying, if you passed away with a partner, then the next question is, did any children or grandchildren survive you? If the answer is no, and you pass away with just one partner, no children, the partner gets the entire estate. All right? This is according to law. Or if you pass away with a partner with surviving children or grandchildren, then the next question is, if is one partner with children of the relationship, partner gets the entire estate. Your estate simply means the property and the monies that you left behind. Or if you pass away with one partner with the children from another relationship, your partner gets what they call a statutory legacy, which at the moment is about 461,000, and then half of the balance and the children will get the other half. So it's all run by formula. And if you said that, no, that's not what I want to do, then I'll tell you, write a will. If we go on the other side, you pass away without a will, without a partner, no surviving children, then the question is, do you have surviving parents? No surviving parents, then what about surviving siblings or children of deceased siblings? So that's if you have nephews and nieces. What about surviving grandparents? What about surviving aunts and uncles? Only when they just about exhaust this whole list, then it goes to the crown. The government will take it. All right. So I assure you, the government isn't just going to be there and grabbing the money that you left behind. It goes down a fairly extensive and fairly long list. So for some of us of the Chinese descent, your Ima Kuche will probably still get something before the government gets hold of it. All right. So that's really a snapshot of wills and why you should get yourself a will. I'll share something very personal as well. I got people asking me, said, "Oh, Peter, I'm young. I got no assets to my name." And I see some young couples present this afternoon. My question to them is, do you have children under 18? And if the answer is yes, then I'll tell you, you need a will. Simple reason is because in the will, it's going to specify who is going to be the guardian. And we had one case where a young couple passed away in a car accident. This happened about a year and a half ago. They had one child. Father and mother were taken out at the accident. The parents of the father were staying with them, and all of us would think that, of course, the grandparent will take care of this child. Department of Human Services just asked the question, where's the document that says so? Where's the document that appoints the grandparents as the guardian of this child? Because both of them passed away without a will. Unfortunately, in that circumstances, the DHS actually has to take the child away. They had then put in urgent representation to the court to appoint the grandparents as the guardian. That still took 2 weeks. Meantime, the child has to be removed. You can imagine the trauma that has gone through both the grandparents and the kids' world, you know. And if you know, honestly, just write a will saying that, well, in the event I'm gone, my mother will be the guardian to my kid, problem solved. So even you say that I got no assets, I got nothing to give away, but you have children, you have the responsibility to protect and provide for the kid. So I'm just about done, and we'll come to Q&A. So I'll throw it back to Pastor Chee, and I hope you all would have taken something beneficial from the talk today. And if there are things that I could help answer your queries, fire away in the chat or in whichever way you can get the questions across, and I'll see how I can answer them. Thank you.
Great. Well, thank you, Peter. That was super duper helpful. I guess from my personal point of view, many of you guys would know, obviously, I lost my wife 2 years ago, and we didn't have a will. And having to walk through just the logistical issues around all that kind of stuff was just not an additional extra burden that you actually want to have to deal with, let alone some of the complexities that you have raised. So I really do think it's really wise and advisable. I think some of the things that you've advised us is very, really super duper helpful, especially even from a biblical sense, some of the stuff that you brought in. So thank you, Peter. So what we'll do, if you have questions right now, why don't you put it into the chat line? But I'll go into some of the questions. So between myself and Juliet, we'll ask some of those questions. Yeah. The first one, I'll just throw in mine, is what do you think about doing wills from the post office? You know, those will packs. What are your thoughts and opinions about it?
Right. Will kits from the post office is perfectly all right as long as you meet the formalities. However, the will kit from the post office only asks you certain very standard questions, and therefore could potentially leave out some other questions that you may not have thought of. For example, we had a client who was in his second marriage, did that in a post office will, but did not mention why he wasn't giving anything to the children from the first marriage. He then passed away, leaving nothing for the children of the first marriage. They brought the matter to court. Unfortunately, his estate was only about 180,000. By the time they finished fighting, legal bill was in excess of 20,000. So 20 out of 180 didn't seem, you know, a good deal to anyone. But if they had actually gone to seek professional advice, one of the questions I've asked is, so you actually have to draw me out a family tree, and you're telling me that this is your second marriage. I'll have to ask you then, what about people from your first marriage? Ex-spouse, are you under spousal maintenance, children, and all that? So it has to be more comprehensive, which post office will does not provide.
Okay, that's great. Now, thank you for that. I think that's one of someone's questions down there as well. So I'll ask the next one, and then I'll hand it to Juliet, and we'll kind of tag team. So one of the other questions at the top was, what about if the witness passes away?
That's fine. That's not usually a problem, as long as we know that there is no challenge, or there is no challenge to the fact that the will maker at that point did not sign it under duress or was not mentally sound. Because
so they pass away.
Yeah, so the witness, right? Yeah. So it's only when there is a contest, and we want the challenge is that the will maker was mentally unsound, was under duress, then the opinion of the witness will be required.
Okay.
So if in a normal situation, that's fine. That's well and good. That's not a problem.
Okay, great. Jules?
So to follow on from that, so if in your case, if the witness had passed away, do you recommend that you then go and get it signed again in front of a new witness? Is that necessary?
In general, no, that's not required. That's not required. But I see a question. I'm going to just jump on ahead because what if the executor or the trustee passed away?
That's another question somebody has asked.
Yes,
Correct.
that's right. So one of the things we will advise people to actually do is to have 2 or even 3 executors or trustees. So the first one being the main person, and then these 2 are what we call substitutes. And this is in the event that, as asked, if they were to pass away. But even before doing that, one of the things, of course, is don't name executors or trustees who are older than you. Because chances are they'll probably sign off earlier than you do, right? So certainly find somebody of at least your same cohort or some people who are younger. Now, having said that as well, if you have the sort of luck that some of us do, all your executors and trustees pass away, it is also not a deal breaker. Essentially, you could go to the beneficiaries or the people you left behind could still go to the court and apply to appoint somebody else as the executor under those circumstances. So it's not a deal breaker.
Yeah, no, that's great. Another question, if I pass away without a will, do my relatives overseas get a share? So I assume it's the distance, geographical distance. Does it make a difference?
Geographical distance is not a problem.
Okay. Yeah. Okay.
Yep. And another question, I guess, perhaps from a mother's point of view, for the mothers who maybe don't have a will, and I don't actually, I need to do one. So as far as if you touched on at the end of your talk, if parents pass away and you haven't got a will as far as guardianship of your children, is there a particular order? So you're saying that DHS will, at the first point, take kind of custody until it's worked out or contested by other parties who is going to take guardianship. Is there a particular order that the court will automatically assign, say, fathers, the children's father's family as opposed to the mother's family, that kind of thing?
That's a good question. Now, essentially, a guardian will be required when both parents are no longer around, right?
Yeah.
So as long as either one parent is around, that's fine, because
Yeah.
the parent naturally becomes the guardian. Now, in the event both gets taken out and there's no will, like the example that I've mentioned, and you got both grandparents fighting for the grandchild, right? I really can't tell you how the court would judge, except to say that essentially they will always look at the best interest of the child.
Yeah.
But rather than go there and take a chance, why don't you write a will and specify who will be the guardian?
Yeah.
Yeah. Great. Do you have any tips around that, around who you think, some of the things to think about and who we appoint as guardians? I mean, obviously in my situation, if I pass away, I needed to find a guardian, right? So that's why I've done my will and stuff. But do you have any advice around how to go about that thought process?
Look, contemplating your own mortality is very confronting. Yeah, I think let's address that first and foremost. But like I mentioned, death comes to all of us, and it's useful, therefore, to start thinking about some of these things. For those with young children, and it is very real. We can all get taken out very quickly. So, who do you think would love the child? Not as much as you do, because that's impossible. But who do you think will love the child and be able to raise the child in the manner that you would like to? That's for your thinking process. For many of us, myself included, I'm what I'll call a first-generation migrant. I've got no family here. So what happens under those circumstances? And you need to think about that. Would my sister who's overseas, would my brother who's overseas be able to play that role? They love my children, and I'm sure they would. But how are they going to manage that from an overseas point of view? And that's something you need to think I pray it won't happen, but you need to think and work that through with your brother or with your sister even now.
So, Peter, you're saying the guardians can be nominated from overseas, but obviously it's your personal decision making about whether that's the most appropriate choice.
Yeah, that's right.
Yeah.
The actual practicality becomes a lot more challenging though.
Yeah.
Yeah. Okay. There's another question. There's a lot of questions. Good. So a will can be written on any piece of paper and signed off by 2 witnesses? Question mark. Or is there a template of some sort?
No, I've seen it written on envelopes before. Not personal, not a personal experience, but as an example that was shown to us, saying how wills or where wills can be written. There was this matter where the person was actually dying in the hospital. They could not get a lawyer to the hospital fast enough. They actually just grabbed and the back of an envelope and the scribble. The doctor and the nurse was the witness, and it was accepted by the court.
Okay.
Not the most ideal. Let me say again. Law changes from time to time. These days, the law does not favor the doctor to be one of the witnesses, right? It's not forbidding, it just does not favor.
Yeah. So yeah, okay. As long as, so it's based on essential situations rather than being lazy, right? Okay.
So what then would you say, I think there's a couple of questions about what are the various pathways you can get to this end goal of having a comprehensive will? What are the best options? Obviously, as a lawyer, you can sit with a lawyer and draw one up, and there's online, is there packages, or people are sort of wondering what's the best, or what are the options for a comprehensive will?
Sure. I would always say to get the proper advice. Internet can be the internet, as we all know. If there's a saying, if it's on the internet, it must be true, right? So if you want to do your research on the internet, look, I'm not stopping you, but again, based on what I've shared with you, as long as it meets the formalities, then your will is valid, right? But certainly, if you want to do a lot more research and do things by yourself and so on and so forth, nothing stops you from doing that. Okay, but I would certainly recommend that you seek the advice of people who knows how to do this.
Sure. And I think somebody has asked you, in that case, if you go through the lawyer, can the lawyer play that role as the executor, or can they play a role in which roles can the lawyer play as far as signing off? And
Sure. The lawyer certainly can play the role as one of the witness. As to I think I did notice the question whether a lawyer could become the executors or trustees. The simple answer is yes, but it does get a lot more complex than that because of potential conflicts of interest and so on and so forth. I personally wouldn't want to be named on my client's behalf. But if it's a friend, that might become a different story. Yeah. And certainly there are situations where the executors themselves don't want to handle the work, and that's where they can actually then the executors appoint a law firm to then run the rest of the show, and that's fine as well.
okay.
So based on that, if someone flip it the other way around, if someone approaches me to be an executor, what are the things that I need to think about in saying yes or no to that situation?
Let me say first and foremost, it's probably an honor to be asked, because remember, what are some of the requirements to be named, to think about in appointing a executor? Person of integrity, person who can run businesses well or do things, in a very proper manner. So they obviously think that you could do that, and that's why they'll like you to name you as an executor. If your relationship with the person is close, like I said, I certainly think it's an honor, and to consider doing so rather than turning them down. But having said that, because of the closeness of relationship, when that person actually passes away, you might be so emotionally distraught that you cannot do the work anyway. And that's where potentially the substitute executor can play that role, or the decision to appoint a law firm to do the work.
Yeah. So you can have your name there, but you can always decline a little bit later, and it just goes down the list.
Yep.
Yeah. So just going along the same thread around guardians so that we can kind of complete that topic. One of the questions was, what if I nominated a guardian who's living overseas?
That can be done. It's just different layers of complication and difficulties to accomplish that, because the guardian needs to be providing care to the child, and you're overseas. How does that work? Is the child going to then go overseas with the guardian, or will the guardian then come here? I don't have the answer for you. It's something that you have to think through.
But who has the legal decision making around that? Does the guardian have the right to make those decisions where the children ends up being?
Yes.
Yeah. Yeah. So it's not necessarily stipulated in the will.
No, but it certainly will be something that the will maker should have a conversation with the guardians like now.
Okay.
Like, well, if I die, I recognize the fact that you are based overseas. My children are here. Feel free to take them to where you are.
Yeah.
You can't expect the guardian to unplug themselves and then come here to take care of the child.
Yeah. Just as so in a similar vein around the guardians, one of the questions was, do I need to get the guardian consent acting as guardian for my child documented in the will?
The consent need not be documented, but certainly consent should be obtained.
Yeah.
You don't want a situation where, I pass away and at a funeral or shortly after the funeral, they open up the will and said, oh, Chee, you are the children's guardian. And then Chee goes like, what? Never knew about this, never talked about this before. All of a sudden, I'm a guardian to 3 young kids, So certainly conversations like that need to be had.
And also because they can always say no anyway, right? So it works against
That's right.
you to not have that conversation.
Right. Yeah.
Yeah. Okay. Jules, the question about my husband has property, I think.
Yeah, I'll just read it out so that I get it right. So there's a question that says, my husband has property in his name as he went to sign the contract while I was unable to. Do we need to change the name of the owners on the contract, or will the property be transferred to me if it's in the will? Or what if he didn't have a will?
Okay, there are multiple
Yeah.
there. First and foremost, has the property settled? If the property has not settled, then certainly the wife could get her name included into the contract by way of a nomination. Okay, that's number one. Number two, if the property has already settled, and this property is the principal place of residence, as a spouse, you can get your name added into the title without stamp duty. And number three, if it's all done and dusted, the person passed away, then the property will be dealt in accordance to the will.
Okay, great. There's a lot of questions. Are there recommended place location services on where to store the will once you've completed it or executed? If you were to unexpectedly pass, how do the people left behind know where to find this will if you haven't advised them?
Very, very good question. In the past, there was a registry that was operated by the court. That no longer applies. Will makers are advised to keep the wills themselves. I would say that's probably a good thing to do. Keep it yourself, but certainly let your executors know where it is kept or how to access it in the event that you're gone.
Yeah, because they can either you give them your lawyer's contact, or you can even make a copy. Is that right? Yeah,
a copy of a will does not work for probate purposes. That's the process will apply for the work to be done after the person passed away. An original will is required.
Okay, yeah, sure.
Some law firms does have a custodial service. In other words, they store the will for you. Some law firms don't. So you just have to go ask the questions.
I see. Okay, great. Jules?
I think there's a question about websites or law firms that you might recommend. Perhaps we will ask you that at the end. I don't know, Chee, whether we want to just have a list of things that, I don't know if Peter, you want to recommend any in particular, or how you want to do that, but there's a question about that.
Sure. Writing a will is a very personal thing. I think if you go to a website, you will not get that that sort of service. Number one, you will not get the attention that is needed. in a will. Now, most of us are very straightforward. I die, everything goes to my wife, and if she's not there as well, everything then goes to the kids in equal shares. But there are many circumstances that sometimes that needs the interviews by a lawyer before you actually find out, and then be properly addressed in a will. Law firms, sure. There's I think Tutin is in here. Hi Tutin, and I operate a law firm as well. But for me to recommend websites and all that, I think that's going to be very, very challenging, because I can't in that way recommend a website on how to draft a will.
Can I ask, because a lot of those questions often comes from because it's the cost issue, right? So just it's a ballpark figure.
Sure.
How much would, if I went to a lawyer, solicitor, whatever, to get my will done, what's the price range that we could expect? Because I think this would help us understand.
Sure.
Yeah.
I have heard in the market that there are wills going for 110, right up to $1,500.
Okay.
So if you're coming to me, no, I'm not.
But yeah. So like if you go to the 3,000 mark, that's really, really expensive kind of thing. Like that's, yeah. Okay. So I hope that's helpful for us to be able to help make some of those decisions. Is everyone okay to keep going for another like 10 minutes? Because I think there's a lot of questions. Is that okay? Yeah. Peter, are you okay with that?
Yep. Perfect.
Thank you so much. Okay. We'll ask this other question. I'll try and read it. How would property, I think if registered as tenants in common work, sorry, let me read it again. How would property is registered as tenants in common work if the owners are in a spousal relationship? Would the balance go to the survivor, or does it need to be specified in the will? How would the ATO treat this?
Okay, there's just a little by way of background. You can hold property in two manners here in Victoria. One as joint owners, one as tenants in common. Now, in joint owners, in the event that, say, between the owners, not necessarily husband and wife, but when one passes away, it automatically goes to the other. So that's a question of survivorship. In tenants in common, you can actually specify the amount of ownership, right up from 50-50 to 1-99, right? And often that sort of method of ownership is done maybe because it's an investment property, number one, or maybe it's actually a property that's held that you enter into with friends. So if I entered into this property investment deal with a good mate of mine, I don't want it to go to him when I pass away. I want to make sure that it goes to my wife when I pass away. So that's when it's tenants in common, it will be distributed by will, not by survivorship.
Just for those who don't know, what's tenants in common?
Tenants in common is just a way of whole property ownership that defines the actual amount of ownership instead of joint. So you just have two types, joint owners and tenants in common.
Okay, that's great.
A question is, I think we probably assume that it might be common to have a will that just divides all the estates equally among your children. Is that common?
Yes.
It's common to do that, yeah. So in what situations would we consider reviewing that type of will that's already in place? And hopefully we're not going into that territory of one child is out of favor and one is, like you alluded to before. What situations would that be called for?
All right, just before I answer that, let me say also that when you actually plan to write a will, keep it simple. The reason why you should keep it simple is, when is a will read? A will is read when you're not around, isn't it? And at that time, you certainly hope you hope that the people who survive you would be grief-stricken by the fact that they've lost you. Now you're going to pull out a will or a piece of document that states, like any physics teacher in here or maths teacher, it's going to read like a mathematical formula. If this happens, if not that, if not, then otherwise we can go to this. But if that person's not that, otherwise, you know what? At that point, people are not going to remember you well. They're going to, literally, they're going to curse you, right? So keep your will simple. Really, I can give you live examples of why you should do it. All right, but this is not the time. And then to address your question, whether it should be equal distribution or not, this is not legal, but this is a personal opinion and recommendation. It should always be seen as fair as possible. It should always be seen as fair as possible. Why? You are gone. You are gone. You're not there to defend why you did what you did, you know. But the person who might have received the lesser portion, why? I was Dad's favorite son. Why did he give me less? I'm going to sue the estate. There we go. Then you're helping make the lawyers rich. Thank you very much.
To throw something in there. So what happens if you deem one child to be not wise in their stewardship and it wouldn't be a blessing to them?
Mm-hmm.
How would you make decisions there?
Potentially then create the testamentary trust after you're gone.
Yeah.
So they didn't get the whole lump sum.
Yeah.
They will get it in a way that you decide.
Okay.
Or the trustee will be in charge of it and it will be given out whether in a drip feed sort of manner or in a manner that's most helpful to that person.
Yeah, so fair in the amount, but how it's actually distributed is with wise stewardship.
That's right.
So in light of that, that's one of the questions for those who are not familiar. So what's the difference between a will and a testamentary trust will? Do we need to do a testamentary trust will for asset protection and taxation planning for beneficiaries who are not necessarily those disabled or minors?
Oh, that's a very, very big question.
Yeah.
I don't want to overlay the prompt too much with tax, particularly after that, yeah. But just to say, between a will is a will. Now, let's say the first example, and I die, everything goes to my wife. If she's unfortunately not there, everything equally to my kids. That's just a will. And I die, and because one of my kids could be physically or mentally challenged, so therefore, giving him or her the share of the estate may not be helpful because they won't be able to manage it. So it then gets into a testamentary trust. So that will is just called a testamentary trust will.
Yeah. Okay. If you can pause on the questions, I will try and finish whatever is there. There's quite a few overlaps. So hopefully then later we'll kind of finish off with some commentary at the end.
So Peter, that testamentary trust will, does that also apply to, there's a question that says, is there a maximum age for a child to be on guardianship? For example, if they have no parents living any longer and they're only 18 and they become an adult legally, but they're not wise enough to manage the assets that have been left to them. So is that in that case where a testamentary trust will should be put in place?
Right.
For a child who's...
One, guardianship is 18. Yeah. Guardianship is 18.
Yeah.
But many of my Asian clients think that 18 is too young to have the children to have all the monies.
Yeah.
And for Asian clients, I'm looking at 21 to 25 years old. Right? And I see a lot of Asian face nodding their heads right now. For my Caucasian clients, they actually think that 18 to 21 is perfectly fine, right? So I'm not saying what is right, what's wrong, but it just shows the difference in the cultural approach and the mentality. The testamentary trust will essentially continues until the estate or the portion of the estate actually expires or is exhausted.
Yeah, that's great. Now, what happens if the property is still under mortgage and the property goes to the children? Does the debt go to them as well?
No, it has to be paid off first.
Yeah. So they basically collect all the estate, pay off all the debts, whatever's remaining then goes to everyone else. That's
correct.
Okay.
Does a married couple do the will together and have one will, or does the husband and the wife have a separate will?
Husband and wife separate wills, but your conditions could mirror each other. This is what we call a mirror will, right? The reason why you don't do one will is, for example, if one party passes away first, you need the original will to apply for the probate. Then the other party now doesn't have a will. Yeah. So two wills, one each. The terms can mirror each other. That's fine.
Okay.
Now, can you explain the word probate? Because
Sure.
I had to go through that. So yeah.
Probate is the application that you do when a person passes away to give authority for the executors to carry out the wishes of the deceased. Right? So it's a document that you apply to the Supreme Court.
Yeah. Great. Now, in case of shared assets, do our beneficiaries need to align?
Ask that again.
Yeah, it's a bit confusing. In case of shared assets, do our beneficiaries need to align?
In a situation of
Or shared assets, yeah.
will. Yeah.
Yeah.
This is getting a little bit more technical.
Yeah.
So you have a mirror will between, say, the husband and wife. There is this presumption in the wills that if somebody passes away 30 days before you do, it is deemed that the person has passed away later. All right, but let's not get into that. But everything will go according to the will of the person who passed away later. So your beneficiaries need not align. All depends on who died first.
Okay, yes. Yeah.
You get what I'm saying?
Yeah.
I can always say that when I die, my beneficiaries is A, B, and C. And my wife could write hers and say hers is D, E, and F. But where it all goes to really depends on who died first.
Yeah. Okay, that's great. Just a few more, and then we'll kind of land the plane. Can a will made here cover distribution of assets if they are in multiple countries? For example, some here in Australia and also in my birth country.
Sure. It can be done. It just makes the whole process a lot more complex. So we are recommending that you should have a will in every jurisdiction. All right. So for example, certainly a will here in Australia, and if you do have assets in your country of birth and other places, and it's very common these days with international investments, our recommendation certainly is that you should have a will in every jurisdiction where you have assets. Bear in mind, it's a recommendation, right?
Yeah. Okay, sorry, Jules. We'll just do three more. One is, if I own an investment property in my name only and I don't have a will it go to my spouse automatically, assuming there's no previous partners?
Then we have to go back to the graph. So if you die without a will, you have a partner, you have children. If the children of that partner, then it will go to your spouse.
So this is investment properties as well as primary residence.
Well, depending on who owns it.
Yeah. Okay. I think this was helpful. This one. Should we mention about our superannuation in the will? A lot of people may not be aware that they have to sign a binding nomination with their superannuation, which has to be renewed every 2 years. That's a good point. Thank you.
Yeah, very, very good question. A will is governed under the Wills Act. Then you have your superannuation, which is governed by the Superannuation Act. And then you have the insurance, which is governed under the Insurance Act. You can start to see how it can be very complicated. But in a nutshell, a will does not govern how your super and your insurance gets distributed. All right? It is by a process of nomination. But however, if you want your super and your insurance to be brought under the will, it is a process called a binding death nomination. So really speak to your super administrators, speak to your insurance administrators if that's your intention, that you want your super and your insurance to come under the administration of the will.
That's great. So, I mean, I did that. You just fill in a form. There's a tick box. You just tick the box and you hand it in, and then you just make sure that they've done it on the other side. Yeah.
That's right. That's right.
Yeah. Okay. I was just waiting for whether Chee had a question, but otherwise, I think that's it. Unless, Jules, you can see any others that we've might have missed.
No, I think Peter, you might have already touched on how to protect the child's inheritance. You might have touched on that earlier during your slides. Don't know if there's anything you want to elaborate on that.
Okay.
Yeah, that was it.
Yeah. Well, if not, what we'll do is just really quickly, because look, as a church, we believe that Jesus makes a difference in every single area of our life, and even in the area of estate planning, right? because the vision of our church is to build people, build disciples who represents Jesus to everyone everywhere with everything, even in the area of will writing. So just Peter, just as a question, what are some of the things that's the Christian lens, lend itself into the way we think about this process of will writing?
Look, certainly it's being clear about what your intentions are. Our faith does not allow us to really, just muddle around. And you look at our Lord Jesus, his intentions was obviously very clear. And really, in whether it's will, is in estate planning, it is being accountable, and we are really following the examples that he has actually shown. So that's in discipleship as well. So clearly, estate planning, wealth management, whatever you call it, falls very much under our Christian responsibility as well.
Great. Well, I just want to just share just a few thoughts, and then we'll land it. But thank you, Peter, for that. It was fantastic, super duper helpful. I think just some of the things that I think it's important for us to think about as disciples. I think one of it is, I think it's really a good time for us to reassess the relationships we have. Because at this point, Christ calls us at our best, and it's a two-way street, to reconcile. And I think the ministry of reconciliation, and it prompts some of those things. And we have an opportunity to decide whether we want to or whether it is possible. But I think that's one aspect. I think the other aspect is about stewardship, where your heart is, there your treasure is also. And I think Alex Cook, he really challenged us to go, why does all your stuff need to go to your children if they have enough? And that was so confronting. But I think it's a very interesting point, and I'd like to kind of bring Alex's challenge to our estate planning, to kind of go, if we are protecting, and providing already, and you do have access, I think one of the key questions to be asked is how then do we actually, multiply that beyond just the family who really has enough. And I think the third thing is around, and this can seem a little bit morbid, but I think like what you said, Peter, it is important for us to address the areas of our passing and our funerals and our death. Yeah, I'll leave us with this scripture. I mentioned this in funerals that I do, and it's found in Ecclesiastes 7:2-4. And it says, better to spend your time at funerals than at parties. After all, everyone dies. So the living should take this to heart. Sorrow is better than laughter, for sadness has a refining influence on us. A wise person thinks a lot about death, while a fool thinks only about having a good time. And I think it's important for us, especially when we're estate planning and we're thinking about these things, that not to kind of walk away from it, but to let it have a refining influence on us, refining in the way we think about stewardship around our future. When we do pass, do we really believe that, eternity is ahead of us? And for it to have an influence on the way we see our relationships and the work that we might want to do to bring healing to it. So I think that's some things for us to think about as followers of Jesus in this area. Absolutely. Yeah. Any other comment, Peter?
No, all good. Let me do a little piece for BSF as well. We did the people of the Promised Land last year, and when at a summary, we were asked, what do I think? And I said, look, when we started with the book of Joshua, Moses died. And then as you read on, this person died, that person died, David died, Solomon died. And what does it tell you? What does it? We all get to face death. And in a real sense, writing your will doesn't mean that you could extend it or you could change anything. But rather, it is just making sure that when you are gone, the people who survive you can have a slightly easier time. And that's just by stating your wishes, stating your intentions, and stating your objectives.
Fantastic. Thank you, Peter. As someone who's obviously lived that out, and something that Peter has said that oftentimes he does presentation like this, and who writes a will, sometimes people don't do it. So my encouragement is not just to hear it, but to do it. Yeah. So thank you, Peter. But otherwise, we're pretty much done. And so what we've done is we've actually sent a SurveyMonkey link to all your emails. When you log off this chat, Zoom chat, if you could just go into your emails and just respond to that, that would be super duper helpful. It'll only take like 2-3 minutes, and that will be really helpful for us. But a massive thank you to you, Peter, to Jules, to Nick, as well as to Chee and Greg for initiating this, and to everyone else as well. Thank you, guys.
Thank you. Thank you very much for having me. God bless.